Attention please, ladies and gentlemen, we will be beginning the proceedings this evening, so a kind request for all our guests to take their seats. Ladies and gentlemen, good evening and welcome to the Golfers Hotel in Colombo. For those of you joining us physically here in Colombo, and to those of you joining us from around the world, from Kenya, Uganda, South Africa, India and Singapore, a very warm welcome. I'm Aditya Singh, your host for the evening on behalf of the Moot Society of Sri Lanka Law College. Now, ladies and gentlemen, the Sri Lankan bar has never had a lack of talent. I think the fact even stands true of the bench as well. But every once in a while, a great legal luminary is born. And this legal luminary illuminates the bar and drives it to a higher standard than it was earlier. Ladies and gentlemen, today we are here to celebrate the legacy of one such exceptional individual who brought the Sri Lankan bar up to a different standard. And that, ladies and gentlemen, is the late great, the legendary Herbert Victor Pereira, Queen's Counsel. And while celebrating the legacy of the great Herbert Victor Pereira, Queen's Counsel, we are also here to celebrate the inception of greatness. The greatness of young budding lawyers who took part in a grueling competition and who have won just through participation. And so, ladies and gentlemen, we are witnessing the final celebration of passion, excellence, and the spirit of justice. Ladies and gentlemen, let me formally welcome you to the closing ceremony of the Herbert Victor Pereira Memorial Moot Competition 2024. And to now find out why this year's edition of the H.V. Pereira QC Memorial Moot Competition is different from its previous iterations, let's all take a look at the screen.
Since the dawn of civilization, creators have faced the challenge of protecting their innovations and inventions. Today, in this fast-paced world we live in, those struggles have evolved into sophisticated legal battles waged on the battlefield, that is, intellectual property law. But when those conflicts manifest in court, the litigants often find themselves stuck in lengthy and expensive legal battles with no end in sight. Enter intellectual property arbitration. Because why spend years in court when arbitration can deliver justice in a fraction of the time? Why spend so much on extensive court battles when arbitration can resolve your conflict for a fraction of the cost? So what can we do as law students to further develop the already expanding field of intellectual property arbitration? We can spread the word of IP arbitration around the world. We can forge the future guardians of intellectual property in the fires of competition. We can create a network of leaders who will one day take on the helm and guide intellectual property arbitration down the right path. And so, to turn vision into reality, the Moot Society of Sri Lanka Law College proudly presents the H.V. Pereira QC Memorial Moot Competition 2024.
The Victor's Moot 2024 revolves around intellectual property arbitration, an emerging field in the realm of alternative dispute resolution. Participants will explore the intricacies involved in the coexistence and infringement of similar trademarks in different jurisdictions. This will involve examining the nuances of international trademark law and coexistence agreements while addressing the challenges of enforcing IP rights across borders. This simulation mirrors actual arbitration proceedings, providing a hands-on experience that is both challenging and educational.
We hope that through this,
Participants gain exposure to IP arbitration and recognize its relevance and applicability in resolving IP disputes.
This journey culminates in a celebration of excellence. Join the movement, shape the future, embrace the challenge of intellectual property arbitration. Welcome to the closing ceremony of the Victors Moot 2024.
Ladies and gentlemen, let's hear it for the closing ceremony of the Victors Moot 2024. And now, ladies and gentlemen, to welcome our distinguished guests, our participants, and the organizing committee to this bona fide gathering, I most respectfully invite the Deputy Principal of Sri Lanka Law College, Mr. Shehansi Pereira, on stage. Sir, over to you.
Back in 2018, a group of dedicated, conscientious students decided that it was time for Sri Lanka Law College to have its own international moot competition. This competition has today evolved into what you see today. We must not forget the efforts of that pioneering group of students. I wish they were here today. At the inception, at the outset, I would like for you to recognize their efforts by giving them a big round of applause, ladies and gentlemen. Looking around the room this evening, I see that we have the support of some of the giants in the legal profession in Sri Lanka. We are blessed with the participation and the contribution of Her Ladyship, Justice Shirani Tilakawardena, an ardent supporter of Law College and its students, whose stature both locally and internationally have helped to elevate this event to what it is today. We are blessed with the help and assistance, the support, the guidance of the godfather of arbitration in Sri Lanka, Dr. Kanagiswaran, President's Counsel. We are also so proud to have Dr. Harsha Cabral, a renowned legal professional, a top corporate personality, and a renowned academic. And we are so thankful to Mr. Chandaka Jayasundara, President's Counsel, who has contributed immensely, sometimes behind the scenes. And we are aware of your contributions, sir, and we are grateful and thankful to you. We are also honored by the presence of Mr. Walker from USAID. Thank you, sir, for your participation, your contribution, for gracing this occasion. Can we have a big round of applause for these dignitaries, ladies and gentlemen? When we look at those who have backed this event, we see why this event is what it is today. It has evolved into something which is truly international. I believe this time we have the participation of 18 teams, out of which 13 are foreign teams. I hope your experience has been nothing short of wonderful. Mooting is something that gives the participant the ability to excel in advocacy, research, in presentation. And it is a skill that all students should try to enhance, to improve. However, we find that in most institutions, not everyone gets the opportunity to moot, or some opt not to moot. Why is that? I am reminded of the parable of talents. I'm sure many of you have heard the parable of talents, but bear with me. I will put it to you in a minute. There was once a wealthy estate owner who went on a long journey. And before he went on his journey, he called to himself 3 of his servants. And to the first, he gives 5 gold talents or coins. To the second, 2, and to the third, 1. Upon his return, he calls them and asks them to settle accounts. The first comes up and says, "Master, you gave me 5 gold coins. See, I have got 5 more. And the master says, "You good and faithful servant, I entrusted you with small matters. In future, I will entrust you with far greater things." And the second servant comes up with 4 gold coins, and likewise the master praises him. However, the third comes up with just that 1 single coin that he got. And the master is furious. The servant says, "I buried it in the ground because I was scared." Now, what is the relevance of this parable? The parable ends with the saying, "To those who have, more will be given, and to those who do not have, even the little that they have will be taken away." Now, I used to have a problem with this saying because I couldn't understand it. It seemed manifestly unjust to give to someone who already has and to take from those who do not have even what they have. But later on, I have just begun now to understand what it means. It means that if you are blessed with a gift, a skill, a talent, you must invest it, improve it, put it to good use. And if you don't, even what you have may be taken away. Now, ladies and gentlemen, our students are investing their talents and they have reached certain milestones in their student life. But though the Moot Society of Sri Lanka Law College has always had its doors open to all, not all choose to participate. Is there something that we can do about this? It is my personal view that perhaps some marks could be added to the marks that they gain at the written examination. I believe that written examinations are not a perfect way of assessing a student's capacity. It is not a perfect way. Not just mooting, but other extracurricular activities as well. I think in the future, this is something that we might need to look into, your ladyship. The students who have participated in Victor's Moot 2024 are from around the world. I congratulate you. You are all winners. Are you by some chance waiting for the results to be announced? Yes or no? To be or not to be champions today, that is the question. Well, I'm sorry to disappoint you. It's not my task to announce the winners, so you'll have to wait a little while longer. Remember that you are always ambassadors of your institutions and your countries. To the teams participating in Victor's Moot 2024, I wish you nothing but the best. Thank you for your participation. I would like to thank Mr. Tisuru Hettiarachchi, the chairman of the organizing committee, for a job well done. I hear nothing but praise when we talk about the Moot Society. And it is wonderful to be the deputy principal of an institution that has a Moot Society such as yourselves. I also want to thank Ms. Sayuni Fernando, the president of the Moot Society, whose solid leadership has got the Moot Society to where it is today. Could we have a round of applause for them, ladies and gentlemen? You have often heard people express with pride how proud they are of their schools. But I think the great achievement is for your schools to be proud of you. So tonight I tell you that Sri Lanka Law College is proud of you. Ladies and gentlemen, have a glorious evening.
Thank you, sir, for your words of welcome and also for imparting wisdom among us. To be or not to be, that is the question, as sir said, that we are all waiting for. But while we wait for it, let's honor all the participating teams here with us today and also around the world. So, ladies and gentlemen, we are now about to award the participation certificates for all the participants in this year's edition of the Victor's Moot. Let's start off with Apit Candy Campus, the team comprising Anuttara Disanayaka, Pavara Rambukwella, Rida Tariq, and Veruni Ramagamuwa. Let's invite them on stage with a round of applause. Ladies and gentlemen, next welcome on stage General Sir John Kothalavala Defence University team comprising Ashanti Alvis, Rajind Gunaratna, Tiani Vijayanayaka and Shalomi Fernando. Next up, ladies and gentlemen, give it up for the University of Colombo's team, comprising Hamsna Imtiaz, Pavitra Dulanjali Vitana Rachi, AMPL Parami Amarakun, and NV Senanaika. Ladies and gentlemen, give it up for the team from the Royal Institute of Colombo, the team comprising Mayrati Gangatharan, Sara Gunasekara and Saraya Shabir. Ladies and gentlemen, give it up for the CFPS Law School of Colombo, the team comprising Mali Roshin Dias, Savani Nimhara Mataka Gamage, Nakulugamua Gamage Ishini Sashprabha, and Chavini Lakshani Suryarachi. Participants, you can kindly take your seat while we acknowledge all the participants who joined us from around the world. First, we have O.P. Jindal Global University, the team comprising Tejas Shettikumar Kalatur, Arya Sharma, Devashish Taman, and Srinivasul Gautam. Ladies and gentlemen, let's hear it for the O.P. Jindal Global University. Next up, ladies and gentlemen, we have the National Law School of India University, Bangalore, the team comprising Paras Kethan, Harsh Uhavne, and Ratyanash Garg. Ladies and gentlemen, let's hear it for the National Law School of India University, Bangalore. Next, ladies and gentlemen, is West Bengal National University of Judicial Sciences, Kolkata, the team comprising Prajal Kumar Dam, Akdeep Podyar, Arnav Loral, and Ria Garg. Ladies and gentlemen, let's hear it for the West Bengal National University of Judicial Sciences, Kolkata. Up next, ladies and gentlemen, is the National Law University of Bhopal, the team comprising Adarsh Tiwari, Yash Patidar, Deepika Mohamani, and Padmapriya Pradhan. Ladies and gentlemen, let's hear it for the National Law University of Bhopal. Next, ladies and gentlemen, is Nirma University, India, the team comprising Pratyush Pandey, S.I. Madhumita, Tanish Tiwari, and Akand Kuldeep Singh. Let's hear it for the Nirma University of India. Ladies and gentlemen, next is National University of Singapore, Zheng Shui, Khalistan Tan, Jeshley Chang, and Donny Cristino. Ladies and gentlemen, let's hear it for the National University of Singapore. Up next is Stellenbosch University, South Africa, the team comprising Liam Gleeson, Jean-Monique White, Karina Divang, and Bey Jacobs. Ladies and gentlemen, let's hear it for the Stellenbosch University of South Africa. And last but not least, ladies and gentlemen, is the Cavendish University of Uganda, the team comprising Among Mary Kevin, Ruwina Edgar, Aturia Martin, and Okonga Moses. Ladies and gentlemen, let's hear it for the Cavendish University of Uganda. Ladies and gentlemen, with the participation certificates now being delivered, I most respectfully invite now on stage Mr. Jeffrey Walker, Chief of Party of the USAID's Efficient Effective Justice Activity, to deliver his address to this bona fide gathering. Sir, over to you.
Good evening, ladies and gentlemen. On behalf of USAID's Efficient and Effective Justice Activity, I congratulate all of our young ADR enthusiasts on your exceptional performance in the Victor's Moot. It's a great pleasure to witness how Victor's Moot has provided a platform to bring together such exceptional young talent, nurturing our next generation of ADR champions worldwide. Through the effective and efficient justice activity, USAID is committed to the promotion of alternative dispute resolution practices in Sri Lanka. In view of the general familiarity with arbitration as an alternative method of dispute resolution in Sri Lanka, EEJ is focused among our activities on promoting commercial mediation. However, this does not mean we have completely abandoned arbitration. EEJ recognizes that dispute resolution methods, such as mediation and arbitration, achieve their highest efficiency and efficacy when used in harmony and not in mutual exclusion. International trends in dispute resolution, as reported in the 2021 ADR survey conducted by Queen Mary University, show that the commercial sector identifies the use of arbitration with mediation or negotiation as the winning formula for non-litigation dispute resolution. We understand that Section 14 of the Sri Lanka Arbitration Act, as well as institutional arbitration rules around the world, facilitate this use of mixed methods such as meet-arb, as arb-meet-arb, to achieve efficient and effective resolutions to seemingly intractable disputes. Victor's Moot 2024 focuses on intellectual property dispute resolution and has challenged all the young minds here to familiarize themselves with the WIPO dispute resolution process. We are certain that you have now learned that WIPO, in addition to providing a standalone mediation process, also provides for the use of a mixed method under Article 67 of the WIPO rules. It is against this backdrop that EEJ invites all of the young arbitration enthusiasts present, both in person and otherwise, to expand your horizons on how IP disputes can be mediated and how the harmonization of mediation and arbitration best serves the interests of your future clients. I'm certain that today's panel discussion will provide you with many valuable insights. As nascent legal professionals, we encourage you to equip yourselves with skills from both the School of Adversarial Dispute Resolution as well as the School of Amicable Dispute Resolution. This will ultimately help you to become the resolution lawyer your client needs, not just a litigator or an arbitration lawyer. Let me also share this with you in conclusion. As a former coach of Jessup Cup International Moot teams and an enthusiastic supporter of mooters around the world, I have the highest confidence when I say that you will be the champions of efficient and effective dispute resolution in the near future and for years to come. Thank you, everyone, and enjoy this evening.
Thank you, sir. And with that, ladies and gentlemen, we can break for refreshments. Our organizing committee will direct all our esteemed guests to the refreshment area, but please keep in mind that on the other side of this refreshment break is the panel discussion where a few legal experts will answer the question, is alternative dispute resolution suitable for intellectual property arbitration? So be back in 10 minutes with your delicious food on your tables. We will be answering a very important question on the other side of this refreshment break. Enjoy your meals. Ladies and gentlemen, kind announcement to all of you at the buffet. Please make your way back to the main hall to resume the day's proceedings. Ladies and gentlemen, another kind reminder to all at the buffet. Please retake your seats. We are about to begin the panel discussion. I repeat, all guests at the buffet, please retake your seats. We are about to begin the panel discussion. Ladies and gentlemen, the Victors Moot has had a proud tradition of organizing a series of panel discussions each year during its closing ceremony to nurture the minds of budding legal counsel. And this year too, in a proud continuation of that tradition, a panel discussion has been organized and will be chaired by a few eminent legal professionals with several years of experience in Sri Lanka and also abroad. This year, ladies and gentlemen, we will be talking about, is alternative dispute resolution suitable for intellectual property arbitration? And if I now may have the pleasure of introducing our panelists. First up is Dr. Harsha Cabral, President's Counsel. Sir, if I may invite you on stage. Dr. Cabral is a President's Counsel in Sri Lanka with 37 years of experience in the field of intellectual property law, company law, commercial arbitration, securities law, international trade law, covering both civil and criminal aspects of the said areas of the law. He has been a President's Counsel for 18 years and commands an extensive practice in the Commercial High Courts and the Supreme Court of Sri Lanka, and has 16 attorneys at law working in his chambers. He holds a doctorate in corporate law from the University of Canberra, Australia. In addition to his active practice in court, he has been a counsel in many arbitrations and has served as sole arbitrator, co-arbitrator, and chairman in a large number of arbitrations, domestic and international. He was a sitting member of the International Chamber of Commerce International Court of Arbitration in Paris for a period of 6 years until 2021. Dr. Cabral currently serves as the chairman of the National Savings Bank and the chairman of Tokyo Cement Group. Further, he is also serving as an independent non-executive director of Selinco Life Insurance Limited, Dimo PLC, Haley's PLC, Alumex PLC, World Export Center Limited, Chevron Lubricants Lanka PLC, Dali Property Holdings Private Limited, CCC ICLP International ADR Center Guarantee Limited, and Sri Lanka Institute of Information Technology Limited, Slit International Private Limited, Nanadiriya Limited chairman, and he serves on several audit committees, nomination committees, remuneration committees, recoveries committees, and other related party transaction committees, chairing most of them. Dr. Cabral is a senior visiting lecturer at several universities here and abroad, a regular speaker at public seminars, and an author of several books. He also has presented several papers on corporate law, intellectual property law, commercial arbitration, international trade law here and abroad. Ladies and gentlemen, with a warm round of applause, please welcome Dr. Harsha Cabral, President's Counsel. Sir, please get on stage. Next up, ladies and gentlemen, if I may have the pleasure of introducing Mr. Chandaka Jayasundara, President's Counsel. Mr. Chandaka Jayasundara has been practicing law since 1991, specializing in commercial law with a focus on maritime law, multimodal transport law, international trade law, company law, intellectual property law, and arbitration. He has extensive experience in the Commercial High Court, Admiralty Court, District Court, and the Superior Appellate Courts of Sri Lanka. Key roles included advising the Minister of Justice on the Express Pearl maritime pollution incident from 2021 to 2022, chairing committees for maritime law reform, and practicing in both international and local arbitrations as counsel and arbitrator. Mr. Jayasundara, President's Counsel, has also contributed significantly to legal education. He was a former lecturer in the law of contracts at Sri Lanka Law College, course director and lecturer for the certificate course on shipping law and practice organized by the Ceylon Chamber of Commerce and the Institute of Commercial Law and Practice, ICLP, and a visiting lecturer for the Diploma in Commercial Arbitration at ICLP. Additionally, he has served as a member of the Advisory Commission on Intellectual Property. Ladies and gentlemen, please welcome Mr. Chandaka Jayasundara, President's Counsel, on stage with a thunderous applause. And ladies and gentlemen, joining us virtually, divided by geography, united by technology, is Mr. Jonathan Chu. Mr. Jonathan Chu is an independent arbitrator and mediator with over 20 years of experience in handling a broad range of high-level, high-value international disputes, arbitrations, and mediations as counsel. He is a dual qualified as advocate and solicitor in Singapore and as a solicitor in England and Wales, and his general commercial dispute background covers complex commercial, international trade, technology, media, broadcasting, construction, projects and infrastructure, insurance, non-marine, and IP disputes. Jonathan has advised and represented clients with arbitrations, including emergency arbitration proceedings, conducted under all the major institutional rules, including the Singapore International Arbitration Centre rules, the International Chamber of Commerce rules, the London Court of International Arbitration rules, the Stockholm Chamber of Commerce rules, and the United Nations Commission on Intellectual Trade Law rules. He is also an experienced mediation counsel and mediator, having conducted and represented parties in many mediation hearings, including mediations administered by the World Intellectual Property Organization and the Singapore International Mediation Center. Mr. Jonathan is regularly appointed as mediator and has been appointed as presiding arbitrator, party appointed as sole arbitrator by leading arbitral institutions such as the International Chamber of Commerce and the Singapore International Arbitration Center. Mr. Jonathan is also on the panel of arbitrators of various leading international arbitration institutes. He is a fellow of the Chartered Institute of Arbitrators and currently serves as the vice chair of its Singapore branch. Mr. Jonathan recently established Vantage Chambers PLC, an independent Singapore law firm with a focus on promoting the use of appropriate dispute resolution. Ladies and gentlemen, welcome Mr. Jonathan Chu here with us, joining virtually. And now, ladies and gentlemen, to steer this discussion, it is my privilege to introduce our moderator for this evening, Mr. Shanaka Kure. Mr. Shanaka Kure is an attorney at law with 19 years of experience in the legal practice. He has worked both as a junior counsel to Mr. Romesh De Silva PC, one of Sri Lanka's leading commercial law practitioners, and as an independent practitioner. Mr. Kure specializes in intellectual property rights, arbitration, labor law, human resource-related dispute resolution, corporate and commercial law, and contract law. He holds an LLM in corporate and commercial law from King's College London and is a member of the Chartered Institute of Arbitrators in the UK. He serves as a legal consultant to several corporate entities and is a member of the Commercial Law Reforms Committee subcommittee of the Ministry of Justice. Additionally, he is the convener of the expert committee appointed by the Ministry of Justice for the reform of the law relating to arbitration in Sri Lanka. Mr. Kure is also a visiting lecturer in commercial law and intellectual property rights law for several undergraduate legal programs. Ladies and gentlemen, please welcome Mr. Shanaka Kure on stage with a round of applause. And with that, ladies and gentlemen, I hand over the control of the proceedings to our moderator, Mr. Shanaka Kure. Sir, over to you.
Good evening, everyone. And I want to start off by thanking the organizers for having me here today, just to start things off. Two of my great loves come together tonight, arbitration and intellectual property. And I'm personally very interested to see as to how they converge, in the sense that what are the issues you face when you try to arbitrate an IP dispute. It's been something I've been thinking about for a while on a personal note, and it's something we haven't really come across in Sri Lanka, at least myself personally, but we are very privileged to have with us an extremely eminent panel who possibly has experience in this area, both in Sri Lanka and in Singapore. So without taking up any further time, since we've had all the introductions and we are running a little bit late, I will hand you over. But before I do this, just, gentlemen, just a small point or a guide. So if you look at arbitration as a subject area, and if you look at the concept of intellectual property, as we all know, at the end of an arbitration, what you're looking to get at is an enforceable award. The advantages of arbitration, we all know around the table, but just to bring everything together, so to speak, which is my job, you end up with an award an international arbitration award, which you can enforce in 170 odd countries, thanks to the New York Convention. The problem then arises when you come to enforcement, because, as we know, one of the bars, which is a universal bar, is the question of arbitrability. So now the question on everybody's mind, and we had an extremely interesting Moot problem this year, is, are IP disputes arbitrable? Now, if you look at patent, which is, as we know, one of the important aspects of intellectual property, the fundamental principle of a patent is where an inventor discloses his idea to the state for a period of time, and the state tells him, Mr. Inventor, we're going to give you 10 years, 15 years to cash in on your idea, but after that, you've got to share it with the rest of the world. So we all know of inventions which have lapsed that period, which we are all able to use. Now that is a prerogative of a state and a monopoly given by the state. Now we also know that arbitrability ranges from country to country with regard to IP disputes. On one end of the spectrum, you get countries like Switzerland and Belgium, which specifically tell us that IP disputes are arbitrable. So there's no issue in countries like that, including patent disputes. But at the other end of the spectrum, you get countries like South Africa, which tell you that IP disputes are not arbitrable. So really, the key issue, and if I may call it the elephant in the room, is the question of arbitrability. So I would like to hear from each of our eminent panelists in turn as to how the issue of arbitrability is dealt with when an IP dispute is taken up at an arbitration, then the successful party has the award, and when they go in to enforce it in a country, it could be Sri Lanka, it could be one of the other 170 countries of the New York Convention, how do we get over that challenge, and what are your comments on that? If you could start in the same order that the eminent panelists were introduced, we'll start with Dr. Cabral, proceed to Dr. Jayasundara, and move on to Mr. Jonathan Chu thereafter.
Thank you, Janaka. I think I will first touch on the topic we were deciding for me was intellectual property and enforcement. So I will touch on that aspect, and then Chandaka will take over on the arbitration part, and then we can discuss. I think Chandaka and I must first acknowledge our guru, Dr. Kanagiswaran, who is here. If not for him, both of us would not be talking about intellectual property or arbitration for that matter, or be here. So, thank you, sir. We always acknowledge that, and you have one of the finest gurus we have found, and we have achieved a lot with your guidance. Intellectual Property Act, we have a statute, Intellectual Property Act number 36 of 2003, which is based on the TRIPS agreement. Prior to that, we had the Code of Intellectual Property, which was a codification of all the laws that were there at that time. It was 52 of 1979, which followed the WIPO model law, because all Merchandise Marks Ordinance, Copyright Act, all these were all over the place. So thanks to Mr. Lalit Yatulat Mudali, and with the assistance of Lakshmana Kadiragama at that time, who was in WIPO, we followed the WIPO model law for developing countries. But then the WTO came up with the TRIPS agreement to have uniform system of laws in most of the member states. And I think the author is here. Dr. Kanagiswaran was one of the main authors of the Intellectual Property Act, 36 of 2003. So it's a TRIPS compliant law. Most of the jurisdictions follow that TRIPS compliant law. Now it's a fairly straightforward, simple, well-structured statute. And we don't have major amendments yet, one or two very small amendments. And it has 213 sections. Now, it is structured in such a way, from sections 5 to 27 deals with copyright law. The entire copyright law in Sri Lanka is only 22 sections, right? And copyright is not registrable in Sri Lanka. So we have two important sections, 9 and 10, economic right and moral right. But the most important section there is section 22. What are the remedies? What can you get? Injunction, damages, continuing injunction, profits, or whatever. So that is, you have to go to a court to get that. Under the copyright regime, you have to go to court under our statute. Then from sections 28 to 61, you have industrial designs. What exactly? And now that's a registrable right. And you have a monopoly if you have a registered industrial design for a total period of 15 years, 555 into 3. So from 28 to 61 deals with industrial designs. And section 47 says, what are the rights of a registered owner? Now those can be enforced in the court, only in a court of law. The statute says so. For copyright matters, you go there, and industrial designs. Then from section 62 to 100, you have the patent regime. What is a patent, how to get it, so on and so forth. And section 74 very clearly says, rights of the registered owner. From where can you get those rights? You have to go to the commercial high court. Those are statutory rights. Then you have from 101 to 145, the regime which deals with trademarks, trademarks, trade names, device marks, so on and so forth. Now they are the most important. Now that is, I told you, copyright not registrable. Industrial designs, you have to get a registration. Then patents, you have to get a registration. Then specifically the Act says registered owners' rights, which you have to get from a court of law. And in 100 to 149, which deals with trademarks, now that is, you can either register or be without registering. Then you have to establish that you are the prior user and so on and so forth. There is a very important section 121, rights of the registered owner. So you have to, only if you are a registered owner, you can go for infringement proceedings, that to a court of law. You have to go to the commercial high court. The Act says so. What is the court? The commercial high court, which has all island jurisdiction. Then from 146 to 159, you have another new regime, integrated circuits. There again, 146 says, what are the rights that can be protected? There again, you have to go to the commercial high court. Right? Then comes the most important section, 160, unfair competition and undisclosed information. There again, where do you go? To the commercial high court to get your relief. Very often we go under 160 because it's for the, if you're not registered, you have to go under 160. Then there is a very important section, 170. 170 is the only civil remedy that is available under the Act. I told you copyright, you go under 22, a whole lot of this thing. Then 160, in addition to 160, 170 is the place where you go to get your injunction, permanent injunction, damages, accounting of profit, continuing infringement, all that you go under 170. Basically, 170 is bread and butter for all the practitioners. For years and years, now Dr. Kanagi said for 60 years, he has been benefiting of that section. Right? We get our injunctions, damages, all that. So if we lecture, we can lecture for one day on that because there are so many cases. From 1988 to 2021, I have 2 volumes of reported cases in Sri Lanka. All the cases are there. From 1888, they are reported. So this is the infringement, unfair competition, all those, the access. Where do you get the remedy? Even if 2 parties agree, you can't go and get it from an arbitrator. because these are statutory remedies. And then from 177, now these are civil remedies I was talking about. 177 to 203, you find the offences and penalties. That's the criminal remedy. You have to go to a magistrate court of the area. So you have, for the civil remedies, you go to the commercial high court. For the criminal remedies, you go to the, because the statute says so. All right? And then, well, for enforcement, there are certain things like, obtaining your registration, so on and so forth. Enforcement officer is the Director General of Intellectual Property. Then in our Act, we have sections 206 and 207, where customs, border control comes in, export and import. They are the Director General of Intellectual Property also comes. So we have the Commercial High Court Judge, we have the Magistrate Court, we have the Director General of Intellectual Property, and we have the Director General of Customs. So police might support you for enforcement purposes in criminal matters. So statute says so that you have to go to these places to get your remedy. So there is no dispute resolution, like, then comes arbitrability. You can't even if the husband and wife agrees, shall we go to an arbitrator and get a divorce? You can't get a divorce. So there is arbitrability. The same way, intellectual property, the only where arbitration comes in is with regard to your contracts. Say if I have a trademark and I enter into a contract with Chandaka, right? Say licensing agreement, you can use it in Sri Lanka for 5 years. That is only not with regard to the validity of the trademark or whatever, but this is on how payments and license payments. And if there is a dispute, then that part can go to arbitration. Not with regard to what is provided in the statute. So our statute is very clear in Sri Lanka and most parts of the world. Though we talk about IP arbitration, there is no great thing called IP arbitration. You see, WIPO has that model. WIPO online arbitrations are there. So on the contract, so in the contract you can say, well, whether the payments are being made properly or whether you are misusing it, not whether the patent is valid, whether the for nullity or whether the copyright is misuse or whatever. So, but that is with regard to your contractual obligations, you can bring in arbitration. But otherwise, our statute is supreme. Statute tells you where you can get your remedies.
Thank you very much, Dr. Cabral. That was extremely illuminating. So you set out in brief the statutory underpinnings of intellectual property rights law in Sri Lanka. You set out very clearly that with regard to contracts, so licensing agreements, any sort of contractual obligations that relate to IP would certainly be arbitrable. The question then is as to whether there is any arbitration outside those contracts, but thank you for sharing your view that since these are covered by statute and the remedy is given in statute, that perhaps that might be the dominant remedy. But over the course of hearing our experts, I look forward to a lively discussion on this. So that was the intellectual property rights law. And before getting into the question of arbitrability, Mr. Jayasundara, if you could give us a brief introduction of the ADR landscape, the alternate dispute resolution landscape, so beyond arbitration as well, and then we could look at the applicability of the two. Thank you so much.
Thank you, Shanaka. So I would, when looking at the whole plethora of alternate dispute resolution mechanisms, what would interest us today in view of the subject matter being intellectual property is what are the alternate dispute resolution methods which are enforceable. And to that extent, we are looking at mediation and arbitration. Now, both, actually all ADR, but specifically mediation and arbitration, the necessary factor is that there has to be a consensual agreement between the parties to resolve the dispute by an alternate method of arbitration. So, as Harsha said, to resolve IP dispute by way of using alternate dispute resolution methods, it is essential that it has to arise out of a relationship a contractual relationship which includes also a contractual agreement that any dispute arising out of that original underlying contractual relationship will be resolved by mediation and arbitration. So that's the most important aspect of it. How it differs from what, as Harsha describes, the statutory rights, is statutory rights are given by the state to parties who have certain rights that can be enforced by using the methodology used in set out in the Act itself. So, for example, if there's a violation of, I'll take just an example of a violation of copyright, right? So, if I am a lyricist and somebody uses my lyrics to perform or have a to broadcast or publish a song using my lyrics, that is a right, that enforcement of my rights, because I am a owner of those rights and I can enforce it against anybody who violates my rights. Right. So that is a statutory recognition that is given by the Act to me, which I can enforce through the process or the methodology that is stipulated in the Act. But say, for example, you enter into an agreement with a composer, or you enter into an agreement with a producer, where you contribute the lyrics, somebody else contributes the music, and this producer then produces the song. Now that is a contractual relationship. Now, there is then a violation of the statutory rights as well as the violation of your contractual rights if that producer misuses your copyright, right? Another example is if you take confidentiality agreements, non-disclosure agreements, those are contractual. You have a contractual duty not to disclose the information, but it is also recognized as a right in terms of section 160 subsection 6, where you can use the methodology or the enforcement procedure that is set out in the Act. So either you can opt to go, if there's an arbitration agreement in your NDA, then you can proceed to go to arbitration on a dispute that arises out of that breach of the non-disclosure agreement. At the same time, you do have your right to go into use unfair competition under 160 subsection 6 to go and enforce your rights. So you have two rights that are going together. But trademark and especially patents, it's much more difficult to enforce a patent. It is much more difficult to enforce a registered trademark, because most of the time the violation is done by a third party with whom you don't have any contractual relationship. So if you don't have a contractual relationship, either you have to pull him into an arbitration or a mediation or go to court to enforce it. So for example, Sir and I are having this huge battle about a teaming agreement and a non-disclosure, which is now in the Supreme Court. Now there we are trying to enforce it through 166. But then if there was an arbitration clause in that agreement, because it was a contractual agreement, not a statutory third-party issue, then we could have gone into arbitration. Then the issue arises when you have a statutory right of enforcing your rights, whether Section 5 of the Arbitration Act can take the jurisdiction of the court away. Now they have held in terms of the Companies Act and in terms of the Admiralty Jurisdiction Act in two judgments, one in the Commercial High Court, that if you have a statutory right for oppression and mismanagement, an arbitration agreement in the arbitration, articles will not affect or will not bring in Section 5 because you are exercising a statutory right. In the same way, the right to arrest a vessel in Admiralty, the Court of Appeal has held that is a right that is given which cannot be taken away. A statutory right cannot be taken away by agreement. So even here, you have your statutory rights you can enforce use in the court system. Then you have your contractual rights which arise out of agreement. So the problem, especially with intellectual property, when you look at one thing. One is enforceability. That is difficult. It is much easier by a court order. Number two is that you don't create a public precedent. That is, if I go and enforce my trademark against, say for example, Harsha, there is a judgment of court recognizing my right as a registered trademark owner. But if it is a private arrangement that we resolve the dispute, then we have a problem that won't be a public precedent. Whereas a judicial pronouncement on my rights and the violation thereof becomes a public precedent where others are then bound by the decision of court, especially if it is a decision of the superior courts. So those are basically the fundamental issues, but just to, for completeness, there is no, as Harsha says, there is no magic in arbitration and intellectual property. Arbitration is a dispute resolution mechanism. Intellectual property is the substantive subject matter. So in the same way you can have a construction dispute arbitration, in the same way you can have a maritime dispute arbitration. There is no magic in having, and if you actually go and look at the WIPO rules and all the other intellectual property rules, the arbitration rules are almost the same as any normal commercial arbitration. It's just that now with the development of these new areas of law, especially patent software, software licensing agreements especially, then copyright and mostly copyright. So those are now becoming very, very popular, especially WIPO has gone from just hearing about 200 disputes for years. Now they are going into the thousands of disputes a year. Because now new, especially domain name disputes, intellectual property disputes with regard to software, patents, all those are now going into WIPO because this is a new field that has become, and WIPO has mediation also, MedDAB also is there, MedDAB is also there with under the WIPO rules. So it is a existing resolution mechanism that is gaining ground at the moment. It's as I said earlier, no magic. Construction arbitration, maritime arbitration, intellectual property arbitration. The substantive law is still that substantive law that has always been in existence.
Thank you very much, Mr. Jayasundara. And it's great really to hear from you, particularly the common theme I thought from these two giants in this area of the law, addressing all of you who are just starting off your legal career, to tell you that there's no magic in it is really something special, because there are certain professionals who will try to mystify or jargonize matters, but we have with us seniors, like including Dr. Kanagiswaran, who have always taken the trouble to break it down to us and tell us there's no magic in it. It's arbitration, the law of arbitration, that's just another dispute resolution mechanism. There's a substantive law of the IP Act, and it's just the convergence of using that mechanism to sort a problem out in the IP law. So I thought that was something echoed by both these gentlemen.
Just a point, Shanaka. There is no magic in the concept of IP arbitration. The magic is how to get your client what he wants. That is a magic that you learn somewhere else. As far as IP arbitration is concerned, there is no magic.
Thank you, sir. Thank you. And if I could just draw upon just two things that you said, because I think that will be important in focusing and in preparing for our next presentation by Mr. Jonathan Chu, who is with us from Singapore. You told us that you highlighted a very important matter, which in preparation for this presentation, I too spent some time on. What happens when there's an infringement, a trademark infringement? So you're one of the big brands. I don't want to mention any names here because there might be sponsorship issues. You have to be conscious about IP in so many different ways, but any big brand, somebody goes ahead and infringes. What are the chances that you have a contract with the infringer? Very, very slim. We all know, and you've been mooting on this exceptionally well. I had the pleasure of adjudicating yesterday. We all know that an arbitration cannot arise unless there's an arbitration agreement, which would arise from a contract. So if you don't have a contract with your infringer, arbitration goes out, and you're left with your court remedies. So we can immediately take that out of today's discussion. The second matter which you highlighted, which I thought was extremely interesting, was in slight contrast to what Dr. Cabral shared with us, and really a sort of a modification to what he shared with us, because you drew our attention to the fact that undisclosed information is an area, or confidential information in more simple language, is an area which is very often covered in contracts. If you've ever reviewed or if you've ever come across a label or contract, all employees will have sections in their contract which deals with confidentiality. Now that is contractual. However, the statute, the Intellectual Property Rights Act, also has a statutory regime, as Dr. Cabral shared with us in 160. So there, the very fact that it is in the statute will not perhaps shut out arbitration because it's in the contract and you have a contract. So I thought that also may stimulate the discussion. That being said, thank you, Mr. Jonathan Chu, once again for being with us. We've heard about the IP rights. We've heard a brief introduction to arbitration and mediation. And if we could now hear from you with regard to what your presentation is and your thoughts are of the role of alternate dispute resolution in IP disputes, if you could spend some time on whether, in your view, it's limited to contractual matters, such as licensing agreements, or whether there is any scope, even internationally, in Singapore and even beyond, for matters such as infringement. We would be very grateful. Over to you, Mr. Jonathan Chu. Thank you so much. We can hear you. We can hear you. Please go ahead. Yes.
So, just to pick up on some of the things that have already been discussed, I think clearly the panel, I think many of the audience are also aware that there are many advantages as well as disadvantages to the various forms of ADR. I'm a very passionate believer that ADR actually means appropriate dispute resolution. And what that really means is that it recognizes that there are many advantages and, of course, disadvantages to each form of alternative dispute resolution. Arbitration, as you know, some of the things we've been discussed today, it's a fantastic thing. Of course, great strides have been taken over the last decades, really, in terms of promoting arbitration as one of the leading forms of dispute resolution now. But there are limitations, arbitrability being one of them, enforcement being another one as well. For all the wonders of the New York Convention, I still think enforcement is probably one of the weakest links for arbitration. And so in this case, if you have a jurisdiction where you're seeking to enforce an award on a subject matter where it's non-arbitrable in that particular jurisdiction, then you are likely to encounter some difficulties. Similarly, just to pick up on the point that you mentioned, Shinaka, regarding arbitration and how that comes about as a result of being part of a contract, an arbitration clause between parties. Yes, that's of course all well and good, that's correct. But it's also possible, and sometimes we tend to forget this, that whenever a dispute has arisen between parties who are not necessarily in a contractual relationship. So in your case, if let's say one party's rights have been infringed by another, let's say some IP infringement, and there's also possible in that situation for parties to come into a subsequent agreement purely for arbitration. That means it's an agreement to refer the dispute to arbitration. Now, of course, in practice, that's very, very unlikely that two parties who are in dispute can agree on anything, but it happens. And sometimes the way I've seen it happens that when one party, the infringer, let's say, has been hauled into court proceedings, then in order to avoid the public glare, in order to maybe try to get things resolved in a more confidential manner, that party actually might agree to having the dispute heard in arbitration instead. So it is possible still. Mediation is also where I think, it's, of course, it's something that's really come into prominence of late. And I really think that in the case of mediation, it has many benefits. And of course, there are situations where, again, when parties are not in any contractual relationship, where it's possible to get the dispute resolved through mediation. I'll give you an example. Not too long ago, I was involved in mediating an IP dispute. It was a trademark dispute. And it was a dispute, it was a trademark opposition dispute. And this was thanks to the great work that's done by WIPO and IPOS, the Intellectual Property Office of Singapore. And they have a collaboration where they have a scheme that funds parties who decide to resolve their IP disputes through mediation. And so that mediation is paid for out of this very innovative funding that's provided for them. It really helps to promote mediation. And so as the mediator of this trademark opposition dispute, it's no contract between parties. One party was seeking to register the trademark in Singapore, and of course, there was another party who had an existing trademark in Singapore that sought to oppose the registration. And it was possible to resolve that dispute. It was possible for parties to find ways to sufficiently differentiate a mark. For one party to agree, for example, to withdraw the current application, to make certain amendments, and then to file again. And then the agreement between parties would be there would be no opposition from that particular party if that were to be the case. So again, I'm just giving that as one example of how parties might actually use mediation to resolve the dispute. Now, what's also happened is that, and I think we've heard it mentioned early on today as well, there are very innovative ways to marry more than one process. And so, for example, a dispute that begins in arbitration, let's say under the WIPO rules, it could be under any institutional rules as well, then gets paused and referred to mediation to see if parties can get it resolved. And these days, I can tell you that because I sit a lot as an arbitrator as well, we are encouraged by institutions to broach the subject of mediation. Well, not necessarily mediation per se, settlement. We're encouraged to ask parties if they have explored settlement. And of course, mediation is a great way to get a resolution through settlement. And so in a ARB-MED-ARB procedure, for example, the arbitration's commenced, and then shortly after the arbitration's commenced, it's paused, it's referred to mediation for parties to try to get it resolved through mediation. If they succeed, then the mediated settlement agreement gets recorded in the arbitration as a consent award, which is then enforceable virtually anywhere around the world by virtue of the New York Convention. And there's no harm to the parties if at the mediation stage there is no settlement, because the arbitration has already been commenced. And so what then happens is that we just naturally revert back to the arbitration for it to take its natural course. So that's one way to do it. And institutions, for example, like WIPO, they have gone one step further by even introducing model clauses to promote MED-ARB or MED-LIT or ARB-MED-ARB. It's all possible. So again, one of the ways in which institutions play a great role in terms of trying to promote the appropriate use of dispute resolution mechanisms to resolve disputes.
Thank you very much, Mr. Jonathan Chu. And I think that was really something thought-provoking. In particular, I feel that I had personally never thought about the fact that the role that mediation might play with regard to dispute resolution of an IP dispute. So what you were sharing with us is, even though I posed the question as to what do you do with an infringer, you don't have a contract with them, If, in the instance, one option out is they might enter into a subsequent contract, but that might be unlikely. However, at the Trademark Authority, if there is opposition papers filed, so what you were saying is that at that stage, if they move into the arbitration mediation process, they might be able to discuss as to how they could amend their mark and then move forward in a mutually beneficial manner. And another important aspect, and this is something that, my forays into mediation are more recent than arbitration, and something I found particularly interesting is something you mentioned, where we start with an arbitration, and as you know, the question of whether an arbitration agreement or an arbitration award is enforceable or not doesn't become a problem until after the arbitration. So enforcement, as we know, comes after the arbitration. So if you start off an arbitration, and let's say you start it off in a country where you know that enforcement is going to be a problem because of arbitrability. Let's say it's a country that says, let's say it's South Africa, which my understanding is they say no. Our public policy is IP disputes are not arbitrable. You start off as an arbitration, you stay the arbitration, then as Jonathan mentioned, you move into mediation. And if at the mediation, the two parties who are in opposition at the Trademark Authority can come into some sort of agreement on whether you use kryptonite with a K or kryptonite with a C, as we had in the Moot problem, then you could come back and turn that into a consent agreement, and hopefully you won't have to go as far as enforcement and face the fears and problems of whether IP issues are arbitrable or not. So thank you very much for that, Mr. Jonathan Drew. And those are very interesting insights. So I think the question which I posed at the outset with regard to arbitrability has been explored somewhat. So now from what I've read, and I'm subject to correction, countries like Australia didn't make any changes to the Arbitration Act, but their judges have held that certain IP disputes are arbitrable, and they have gone beyond agreements and so on. But if it comes to a statutory right, like a patent or a trademark, as mentioned by the panelists, then they say that's only between those two parties. It's only inter partes. You can't use it against a third party. Unlike a court order, where if you have a court order, and as Mr. Jayasundara mentioned, if it's a superior court, then it's like a right in rem, a right against, technically yes, it's A versus B. Unlike in a partition matter, it wouldn't be a right in rem, but a superior order would mean you have a greater force against a third party. So one of the ways that countries have got around this concept of how is a private arbitrator doling out statutory monopolies, such as a patent, is to say it will be only between those two parties. So that's one way that they seem to have got over it. I was wondering whether our panelists, illustrious panelists, could share with us as to what they feel in Sri Lanka, for example, because we do have the statute which has been discussed. If we are to introduce arbitration outside licensing contracts and so on, whether you think that is something positive, is it something we need, and if so, does the law need to be amended, or is it better for us to leave the domain of intellectual property with the commercial court? If you could start with you, Dr. Cabral.
Well, actually, there is no need to amend any law. If you look at Redfern on arbitration or Mustill on Biden arbitration, there is a chapter on IP disputes. Well, that has not changed. Right? There are certain matters, say, if a contractual obligation is there and both parties agree. Now, as a colleague from Singapore said, well, there is opposition, there is a trademark opposition. So both parties at that point can agree. Party autonomy is there. Whether we would, we would go before a mediator and resolve this. So it's up to the parties. So the principle of party autonomy is there, but not with regard to whether the patent is valid or whether one party can say it should be nullified. Those are matters for the state, like criminal matters.
Thank you, Dr. Cabral. So there's a clear demarcation as to what the state's role is, their rights, and with regard to what can happen with regard to contractual matters. Mr. Jayasundara,
can I just... so how many IP cases does the Commercial High Court settle, right? So you go into court to enforce a statutory right against a third party. Most of the cases, either at the interim injunction where the plaintiff gets the interim injunction or not, the parties come to an agreement, okay, I recognize you're registered, that you're the registered owner of this trademark, I will change my get-up, I will change my mark, I will pay you some compensation, I will pay you the cost. Now Harsha and I are at the moment trying to negotiate a settlement over a patent, and it's a very complicated patent of using natural dyes to dye textiles, right? So Harsha's client also has developed it in, we say, I don't want to go to the details, but the fact remains that we have come to a understanding where I went into court enforcing it against a third party. We have now come to an understanding of how to work this out. So we are looking at licensing agreements, we are looking at what the licensing amount is. So all that is another, it's not mediation, it's not arbitration, but we are negotiating. So how many do we do? We are, as Jonathan said, you go into court to enforce a statutory right and resolve it by way of mediation or arbitration. That can be done. However, whether the patent should be nullified or whether the trademark should be expunged, those are matters for the state. Those, even by agreement, you can't, because your rights are against other parties also. Now, in Harsha and my that dispute, now we have a common interest now to see that other people don't mess with us. So we can come to an agreement. We can come to an agreement on how to exploit this invention, but we don't want other people to now come and take part of our cake. So now the negotiation is on that. Okay. So this is because if it is to nullify that patent, then we will have to go through the trial.
Just to add something, Chanaka.
Please, Doctor.
Now in jurisdictions like Sri Lanka, we have to take a call. The parties have to carefully consider whether a settlement we enter in court will be stronger than an arbitration award, right? Or a mediation decision. Where do you go from there? Now here, straight away, breach of that, we can go back to court and get whatever remedies. Whereas if it's an arbitration award, you have to go to again to the Commercial High Court to enforce that. You see? Mediation, we have another issue. So, taking into consideration all the repercussions of a final decision is something the parties have to look at and the lawyers have to advise properly.
Thank you very much, gentlemen. Mr. Jonathan Chu, anything you would like to add on from what you've heard from the last two panelists? Sorry, we can't hear you right now. Jonathan, if you could repeat.
Can you hear me now?
Now we can. Please, if you could repeat. Thank you.
Can you hear me?
Yes, we can hear you now.
Yeah, I fully agree with the views shared by the very eminent panelists. Again, I go back to what I said earlier. I don't think we need to try to squeeze everything into one particular form of dispute resolution. It's appropriate dispute resolution, and we need to use it appropriately, right? So if it's best suited for litigation, I think it should remain there. But what I think we need to be more aware of is that there are many situations, many scenarios where if we think creatively enough, I think we'll be able to recognize that, for example, mediation might play a very useful way in terms of resolving that dispute. Maybe it's a situation where you want to preserve the commercial relationship between the parties. That's something that quite often gets it's aborted once you have a litigation or an arbitration which is so adversarial. So you need to find the appropriate cases and then get them resolved appropriately.
Thank you, Mr. Jonathan Chu. And I think you really said you ended with something extremely important. One of the things I've learned since getting involved in mediation is it's possibly the only form of dispute resolution where, unlike arbitration where you have an award against you, or litigation where you have a judgment against you, and you have a winner and a loser, in mediation, since it's conciliation and it comes from the parties, there is no winner and loser. It's a win-win, and therefore very often the business relationship continues. On that same line, since arbitration was the focus, but mediation, today we heard from Jeff as well, they go hand in hand, and should be treated equally. Mr. Jayasundar, you mentioned an extremely interesting fact, and I'm sure Dr. Cabral, you can assist us with this as well. You said that in your experience, all the many, many matters that end up in the commercial court, particularly the IP disputes, with regard to infringement and so on, are very often settled. And I too have had some experience working with Dr. De Silva with regard to one of the parties agreeing to change their mark somewhat, or maybe not to use that particular mark, or saying we'll use a totally different mark and getting approval of the other party. Now, with this in mind, Mr. Jayasundar, Dr. Cabral, do you not think in bringing in, where a plaint is filed in an IP matter, a trademark infringement matter, do you not think that during the period between the plaint being filed, the plaint is the initial document you file in court, and the notice returnable date, which is, I believe, in the commercial court at least a couple of months, do you not feel, gentlemen, that there could perhaps be a panel of mediators who could look into this matter before parties spend time and money on drafting an answer, framing issues, getting into trial, and look into the mediation process earlier, like a court annex mediation process we have heard of in other countries? Do you think that this would be something that would work in Sri Lanka and is something we should look at, or do you think that it would not?
This again is the culture of the lawyers in Sri Lanka.
Quite right, sir.
In other countries, chamber to chamber, they discuss and sort things out. Only as the last resort you court to court. But our culture here is, because maybe we produce 2,000 lawyers a year, right? We have too many lawyers than litigants. You can walk into any courthouse and see today the quality of lawyers, right? So, unfortunately, that should be the thing. Long years ago, I can remember when I was in Dr. Jakanagiswaran's chamber, there was a particular trademark issue. They were basically criticizing the other person's mark. So, we got that particular chairman to talk to the chairman of two big companies. And immediately it was sorted out. Now here we run to court, right? And then, as you say, if you don't get your interim relief, will the returnable date, normal case, regular case, returnable date will be another 6 months or so. And between such period, the infringement goes on. So actually, we do that. Chandaka knows. We, lawyer to lawyer, we discuss and say, well, can't we sort things out? But here it doesn't happen because you want to go and get your interim relief behind the back of the other party. You see? So that culture is not there in Sri Lanka. That is something we have to inculcate. Right? I think that is the quality of the lawyer.
Thank you, Dr. Cabral.
I personally, of course, don't think that you should completely take away the legal system or the justice system. There are certain things that only courts can do. Enforcement of infringing products, or breach of NDAs or confidentialities are so time sensitive that there has to be some mechanism to protect the immediate rights. Arbitration Act in Section 13 gives the tribunal the right for interim measures of protection, but we can't wait till that. And I think the new amendment to the Arbitration Act, which you all were involved, gives that right of giving interim measures of protection to court also. So I don't think the legal system or the justice system is ineffective to the extent of enforcement. But definitely, now for example, under the new Civil Procedure Code, one of the primary matters for the judge to look at the pre-trial conference is to see whether the matter can be settled. So I am actually promoting a situation where between say you go through the pre-trial, and then between the pre-trial and the trial, which is about 3 months, right? So the pre-trial, you identify the issues and sort them down. Between the pre-trial and the trial, which is about 3 to now in commercial high court, I think it runs to about 4 months. 3 to 4 months. I think even Singapore, the time period, there is a time period, a fairly substantial time period before the trial actually starts. So why don't we use that for either arbitration won't work, it won't be that fast, but definitely court, not court referred, court annex is difficult here, no? So at least for the court to refer the dispute to mediation during that period, and by the time the trial comes, if they haven't resolved the matter, you go to trial. But I have a feel, because that's how many cases go to trial, Shanaka, in the commercial high court, only the bank cases. Otherwise, most of the cases, especially IP cases, very few cases actually lead to trial, because in the meantime, we negotiate. Actually, lawyers play the role of a mediator, because we say what is most probable, tell our clients, okay, and so we are doing ADR while doing litigation, right? So I would think the more appropriate thing is between the pre-trial and the trial, if it goes to that stage, try and do a mediation.
Thank you very much, Mr. Jayasundara, Dr. Cabral. So, Mr. Jonathan Chu, you've heard the Sri Lankan experience as to where most of our IP or the trademark disputes generally end up settled. But what these gentlemen highlighted, which is interesting to note, is firstly that it depends on the culture with regard to the chambers. If it's a fellow IP lawyer, you perhaps over the call, you might initiate an informal negotiation. It might be a mediation, but it will be an informal way. And then, of course, what Mr. Jayasundar is suggesting is because of the time lag, which most countries will have between pleadings, before we really get into the main trial, we explore mediation. So that's the Sri Lankan perspective and a little bit of feedback on that. Is there anything you'd like to share from a Singaporean or a global perspective, Jonathan?
Yes. And it's funny I'm hearing this, because over the last few weeks I've had the honor and privilege of being able to mentor a number of Sri Lankan young mediators who are or lawyers and other professionals who are just beginning their careers in mediation. And they've told me the same thing. They told me that culturally there are some things that just go against the grain of mediation at this point in time. I've got two broad observations to make. The first is with regard to timing of mediation. I'll start off by saying that I think by and large I fully agree, and I think I'm in favor of there being some proactiveness in terms of promoting mediation, let's say by the courts, or it could be by other tribunals, trying to recommend mediation to parties. So I'll start off by saying that because I think culturally, especially from where I come from, there's sometimes a lot of reluctance on the part of one party to broach the subject of mediation to begin with. Maybe they think it's a loss of face if they are the first party to initiate or propose mediation. So if it's so-called mandated by the courts or any tribunal, then I think that takes away that face-saving concern that they might have. That's one observation. Of course, in terms of timing, it's a bit more nuanced. It's a bit more difficult to determine when is a good time to mediate. In general, I think that there's always, I think there could be better times to mediate than others, and it really depends on the case. So it's a bit difficult to apply it to every single case that say, okay, the moment the statement of claim is filed, let's say, then okay, 2 weeks after that, let's try to impose mediation. It might work in some cases where at an early stage, or that early stage in the process, you attempt mediation. Similarly, it could be better to leave mediation a little bit later when all the important facts and issues have been surfaced. And then parties realize how good or poor a case they might have. And then they realize, you know what, instead of taking our chances in court or in arbitration, why not give ourselves some control over the process now, control over the outcome by attempting mediation. I tell parties before me in mediations that the mediation is probably the only time they will have where they will have control over the outcome. If you go to court, you go to arbitration, someone else is in control. The arbitrator, the judge is going to be in control over the outcome. But in the mediation itself, that's when parties can actually control the outcome of the dispute, can control the outcome of the settlement as well. They may not like They may not like 100% the outcome, but they certainly are going to be in control and have some say as to whether they can get this settled or not, and if so, on what terms. So that's one broad observation. Another broad observation I have is that I think many of us think about the hardware, what I call the hardware that's involved in trying to put together, the nice and effective laws that promote ADR in our jurisdiction. And Sri Lanka's done a fantastic job with that. I understand that there's going to be ratification of the Singapore Convention on Mediation coming up very, very soon. So, it's easy to put in place the hardware there to facilitate ADR in a certain jurisdiction or community. What I think is more difficult, and I think this is where we touched upon the cultural aspects, for example, the software is more difficult. And by software, I'm talking about people, and people, of course, are parts of different communities, and of course, we've got our culture. That is more difficult to tackle as an issue for the adoption of ADR, whether it's for resolving IP disputes or any other type of disputes. So I think, what we can do to promote the software, to develop the software of ADR, will be things like, increasing awareness of ADR. And of course, the Victor's Moot is doing exactly right, exactly that at the moment. We are making students more aware of what ADR is. We need to do more capacity building to grow different parts of our community that will be involved in ADR. We need to reach out to different stakeholders, law students. We need to reach out to business community, the end users of mediation or arbitration. We need to reach out to counsel who are involved in arbitration or as mediation counsel. We need to reach out to arbitrators and mediators alike as well. So it needs to be a very holistic effort to reach out to all members of that community, all the stakeholders involved, and to get them rowing in the right direction if we want to seriously tackle this issue of promoting ADR where we are.
Thank you very much, Mr. Jonathan Chu, and thank you for highlighting the fact that cultural issues are not just for Sri Lanka, but are a global phenomenon, and as to what steps could be taken in that respect. I'm sorry, we did have the opportunity to open the floor to questions, but the discussion has been extremely interesting, and I'm extremely grateful to all three gentlemen here today, eminent panelists. Thank you very much, Dr. Cabral, Mr. Jayasundara, and Mr. Jonathan Chu for joining us this evening. And ladies and gentlemen, I think a round of applause would be in order for our eminent panelists. Thank you very much for your patience, and I hope you found it as interesting as I did. And we will now hand over back the proceedings. Thank you very much.
Thank you, sirs, for that extremely interesting and intellectually stimulating discussion. We thoroughly enjoyed it, and I think all these young council here today with us also learned a lot from that discussion. And now, ladies and gentlemen, it's time to honor our panelists on stage. And to do the honors of presenting the tokens of appreciation to our panelists, I most cordially invite the chairperson of the Victors Moot 2024, Mr. Tisru Hettiarachchi, on stage. And now, I most respectfully invite Dr. Harsha Cabral, President's Council, Mr. Chandika Jayasundara, President's Council, and Mr. Shanaka Kure on stage to receive the tokens of appreciation. Ladies and gentlemen, let's hear a continuous round of applause for our panelists for taking time out of their hectic schedules to be with us here today and share their insights and intricacies of the law. Ladies and gentlemen, a round of applause for Mr. Chandika Jayasundara, President's Council. Ladies and gentlemen, let's also hear a round of applause for Mr. Jonathan Chu for joining us from distant lands and sharing his thoughts with us here this evening. Ladies and gentlemen, I think almost all of us here within these great halls have not had the pleasure of listening to the great Herbert Victor Pereira, Queen's Counsel, make his submissions in court. But we do live during a time of some legal brilliance. We do live in the time of some of Sri Lanka's greatest legal luminaries. And therefore, ladies and gentlemen, it's my distinct honor now to invite Dr. Kanaganagam Kanageshwaran, President's Counsel, on stage to address this gathering.
Madam Shirani Tiragavadana, Judge, Supreme Court, Vice Principal, distinguished participants, President's Council, ladies and gentlemen, you have been treated to a very erudite presentation on dispute resolution vis-a-vis IP rights. I understand your mood problem was also concerning IP rights. And you have heard a lot from the three panelists and also about magic in these things. So I thought I'd tell you something about a magic which I learned very early in my career. Talking about lawyering, it is about resolving disputes. Disputes always are there and you need to resolve them. But disputes relate to enforcement of rights. Someone say, I have the right to do this. I have a right of patent or trademark if you are talking about IP, or any other subject that I can do this, that and the other. So you are asserting rights. The question is, as a lawyer, when somebody comes to you and says, I must do this, he can't do that. You must understand what is the basis of the right that they claim. That is the first thing you must understand. If you say, I have a right to cross this road at whatever time I wish, where do you get that right from, claim from? So the question is the right recognized in law or is a right enforceable at law? So the first question a lawyer will ask himself is the right enforceable at law? If you sit back and think, there are only two ways in which a right becomes enforceable at law. That is the fundamental magic of this. There's nothing. One is by way of agreement. A and B have an agreement under which A agrees to do something and B agrees it will be so done. So if we don't carry out, then there's a breach of that agreement. There's a dispute. The question arises, how do you resolve that dispute? Ordinarily, we will go to court to enforce the right you claim under that agreement. Or now, arbitration. In my time, it was arbitration. Now there's a new kid on the block called mediation. Mediation, arbitration, all those things are joined. So those are mechanisms to resolve your dispute which has arisen out of a contract. Contract means there's an agreement. So any enforceable right that you wish to resolve by way of litigation, resolution or arbitration or mediation has therefore arisen from the contract. There's no problem. There's no question of can I do it, can I not do it, can it be enforced. You can go to court or you can go to arbitration, you get an award. Mediation also you get an award. And the legal framework will say if you have such an award arising out of an agreement between the parties, which of course will be evidence in writing, is of proof, then it can be enforced. Then the only other way in which you can claim that you have a right against the other is by operation of law. That is, a law says, a statute says, under these circumstances you have this right. If you translate in terms of IP, intellectual property right, you say a patent. Innovation, you get a patent. So that is a right given by the statute. And the statute provides when that right can be taken away, when that right can be nullified, and the consequences thereof. So, if it is a statutory given right, can you arbitrate on that? By consent say, I will surrender the right. No, that is where the statute comes in. That is what the magic they were talking about. Enforceability, arbitrability, all those things arises from the basic precept that any legally enforceable right can but arise out of two methods, agreement or statute. By operation of law, you are given a right. So, if you remember that, then you can resolve all the problems they were talking about. It doesn't mean because the statute gave the right that you have a copyright, that you can't, between yourself, let's solve it. As Chandaka and Harsha and Chandaka said in that order, one is senior, the other junior, you can discuss. As lawyers, you can discuss. That is a private arrangement between the two of you. You don't need to have an agreement, but then after the dispute has arisen, which we do all the time, as they said, counsel to counsel can do that, chambers to chambers, solicitors to solicitors can be done amongst yourselves. But that is only between yourselves, not as against third parties. It's not an in rem, but actually in rem is much wider, much stronger. But this is an arrangement between the two of you. I will not copy your cement mark or Sansa cement. We will not do so. I don't need to go to court. Is it so? Remember, so that's a magic. Magic is simply this. Find out what is the source of the dispute. Does it arise out of an agreement you have between the parties, or is it a right given to you by the statute? So with those few words, I'm sure you will have been enjoying this for a long time. Just as a practicing lawyer, Moot, participation in Moot trains your mind in many ways, making preparation. But when it comes to the practice of the law, you need to slightly tweak it and become advocates. Advocacy is quite different from Moot. Advocacy is persuasion. Advocacy is understanding before whom you are practicing. Before Madam Tilakavadana is very different. Those days, we are happier days. She was tough, but she knew her law. But now it's not so easy. It's difficult, shall I say. So advocacy is to be distinguished from the ability to debate and speak and things like that. So that you will learn over a period of time. So you're all lawyers or going to be lawyers or want to be lawyers or whoever. I wish you all the very best, and you have been exposed to a very interesting discussion on a very complicated topic, intellectual property rights and its resolution. So we have been treated to an extremely useful presentation by all the participants, and I wish you all the very best in your future lives, in your profession. Thank you very much.
Thank you, sir, for sharing your words of wisdom and your intricate knowledge on the law and how it works here in Sri Lanka and even around the world. And now, ladies and gentlemen, it is time to honor Dr. K. Ganageshwaran, President's Counsel, for being here with us this evening and sharing his thoughts. And to do the honors of presenting the token of appreciation, I invite Chairperson of the Victors Moot 2024, Tisuru Hettiarachchi, on stage. Ladies and gentlemen, let's hear it for Tisuru Hettiarachchi and Dr. Kanaganagam Kanageshwaran, President's Counsel. Ladies and gentlemen, President's Counsel, Dr. Kanaganagam Kanageshwaran. Thank you, sir. Thank you, Tisuru. Ladies and gentlemen, after an extensive competition, 2 teams arose to the top and engaged in battle royale to secure the crown that is the championship of the Victors Moot 2024. And now, ladies and gentlemen, 2 of the arbitrators who adjudicated the final round are here with us today, and it is time to hear what they thought about the final rounds of the Victors Moot 2024. Therefore, ladies and gentlemen, please, with a round of applause, welcome on stage Her Ladyship Justice Shirani Tilakawardana, along with President's Counsel, President's Counsel, Mr. Chandaga Jayasundara, on stage to share their thoughts on the final rounds of the Victors Moot 2024.
Good evening, everybody. Both Mr. Jayasundar... I'll be here. No, come and stand. Both Mr. Jayasundar and myself stand before you today very specially for each and every one of the students who are here, especially those who have partaken in the competition throughout. To begin with, we want to tell you that we managed it. The decision was a 2-1 decision. It was that close. We managed to ditch the dissenter out of the panel, because if not, he would have been standing with us. We conveniently managed to. We were the 2 who were for the decision. We want to tell you that the standard was so close, it is unbelievable. But all of you, not just the 2 teams, all of you who took part in this event, please remember that you have learnt a very important skill, and that is to be persuasive in your communications, and that your arguments must be coherent and compelling. That is what underlines advocacy before the courts. And we found that both teams equally spoke clearly, augmented the arguments in a very structured manner, logically, and they anticipated the counter arguments that were brought up. One important factor, and students, please listen to me on this. This is the heart of what you're going to have to do as millennials, as the Z generation, and as millennials, you are going to, the Gen Z generation and the millennials, you are being expected to restructure a value-oriented society. And underlying all your skills, underlying all what you have been doing in organizing and doing this splendid function today is the ethics of it, the diligence of it, and the importance to include the DEI, which the Vice President contesting Vance did not know properly, which means diversity, equality, and inclusion. Now, in that context, I want to particularly tell you, one of the teams in arguing mixed up their facts and presented, I'm sure it was only due to a lack of real concentration on the facts, because where you misrepresent the facts before any judicial officer in anywhere in the world, you lose what is called the uberrima fides, the confidence that the court can have in you as a counsel. And sadly, sometimes that costs, because it means your own integrity in the running through the thread of all the courts in this country. You carry that reputation. So it's important to study hard, because you may not do it willingly. You may have done it in the spirit of competitiveness, but it costs. And that was one of the things that gave us the difficult decision of choosing one over the other fairly easy. In this context, it was fairly easy for us because they lost a lot of points on that. The second thing is the advocacy skills. You know, the connectivity. When you speak in a way where you connect in any court that you stand before the judges. The judge may be competent, lazy, incompetent, anything. But if you stand there with confidence, knowledge of the facts, and with the integrity to be perfect on the facts, you can use your skills of advocacy to bend the law, to stretch the law, but never ever to break the law.
I would just deal with the advocacy part, which I have found during several of these modes, that being 100% sharp on your facts and the law is not the only thing in an arbitration or in court. What is most important, as Dr. Kanageshwaran said, is your persuasive power. If you can't persuade your arbitrator, you might have the best case on facts, you might have the best case on the law, or the worst case on facts and the worst case on the law. Even the worst case, if you are persuasive enough, that is how you win cases, and that's how you win moots. Because you're not talking to trees, you're not talking to statues, you're talking to human beings. And if you don't persuade the arbitrators to take your viewpoint as the correct viewpoint, then however much your presentations, not the presentations, however much your testimonials, your written submissions, you might have the best written submissions, if you don't persuade the arbitrators at the point of making your oral presentation. And one of the important things there is that we judge, because we are nothing like how lawyers get grilled in courts, and how lawyers, now you don't get grilled in law, but you just get hammered with everything else other than the law. Those days when Justice Tilakavardhana was there and Justice Nini and Jayasuriya, they were hammering law and we didn't know what the hell the law was. But now we are getting hammered by completely unconnected statements from the bench that you have no answer. So that's a challenge that you will have. We are facing it now. It will get, I hope it gets better. So what is required is how you persuade your arbitrator or your judge, and that is advocacy, and that is what Dr. Kanageshwaran said, that you have to learn that. And to do that, first thing is integrity, as Justice Tilakavardhana said. If you lose on the first 5 minutes, if you lose your integrity, if you lose the confidence of the arbitrators, it will be very, very difficult to pull it back afterwards.
I forgot to tell you that before we started, I had an urgent whisper in my ear to keep ourselves to 5 minutes because the climax is about to come. So I just wanted to say that I wish each and every one of you students who are beginning a wonderful journey, that you will learn firsthand the transformative power of discourse in the legal profession. Thank you, ladies and gentlemen.
Thank you, madam. Thank you, sir. Now, ladies and gentlemen, it is true that we did have the honor of thanking President's Counsel Chandika Jayasundara on stage by presenting him with a token of appreciation. However, we did not have the time to honor Her Ladyship Justice Shirani Tilakavardhana on stage with a token of appreciation. Therefore, ladies and gentlemen, please invite Her Ladyship Justice Shirani Tilakavardhana on stage once more with a thunderous round of applause. And to present the token of appreciation, please welcome on stage once again Tisru Hettiarachchi, Chairperson of the Victors Moot 2024. Ladies and gentlemen, Her Ladyship Justice Shirani Tilakavardhana. Ladies and gentlemen, before we get to the climax of the day's proceedings, please know that there is a QR code placed on your tables. Please scan the QR code and provide your honest feedback regarding the panel discussion. I repeat, there's a QR code placed on your table. Please scan the QR code, fill up the form, and provide your honest feedback regarding the brilliant panel discussion that we had today. Ladies and gentlemen, we are now at the cusp of excellence. After 2 extensive days of making oral submissions, engaging in back and forth battles between legal points, facts, and improvisation, we are now at the cusp of excellence. We are now about to honor the winners of the H.V. Pereira QC Memorial Moot Competition 2024. And to begin the day's proceedings, I can now feel the tension in the hall. To begin honoring all our winners, let's first start with the Best Memorandum Runner-Up claimant. And ladies and gentlemen, taking the title home of the Best Memorandum Runner-Up claimant is University of Nairobi, Kenya. Ladies and gentlemen, let's hear it for the University of Nairobi, Kenya, comprising Hubert Vendetto, Yarding Ekwa, Kelvin Yaribo, and Max Ayaga Liambila. Ladies and gentlemen, the team. Ladies and gentlemen, to present the award for the Best Memorandum Runner-Up Respondent, I invite Dr. Kanaganayagam Kanageshwaran, President's Counsel, on stage. Ladies and gentlemen, taking the title of the Best Memorandum Runner-Up Respondent, whom is Ladies and gentlemen, give it up for Abbott Law School, Colombo. The team comprising Fatima Rabia Rusina, Sinthuja Shivanesh Raja, Hana Mohammad Basik, and Shashiture Tayaparan. Ladies and gentlemen, the Abbott Law School of Colombo. up, ladies and gentlemen, we are about to crown. So please do remain on stage. Next up, ladies and gentlemen, we are about to crown the winners of the Best Memorandum Claimant. Taking the title home of the Best Memorandum Claimant, ladies and gentlemen, is... Give it up one more time for the Abbott Law School of Colombo. The team comprising Fatima Rabina Husni, Sindhuja Sivanesh Raja, Hanha Muhammad Basik, and Shashidure Tayaparan. Thank you, sir. And now, ladies and gentlemen, we're about to crown the winner of the Best Memorandum Respondent. Taking the title home of the Best Memorandum Respondent is... Ladies and gentlemen, give it up for the National Law University of Delhi, the team comprising Ishaq Jain, Anik Sengal, Abhinav Kumar and Adar Shukla. Ladies and gentlemen, the National Law University of Delhi. Now, ladies and gentlemen, to crown some of the best of the best. We're about to crown the best oralist of the H.V. Pereira QC Memorial Moot Competition 2024. And taking the title of the best oralist of the Victors Moot 2024 is... Ladies and gentlemen, a huge round of applause to Miss Donna Godil of the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. Crown the runner-up Best Oralist of the Victors Moot 2024. And winning the title of the runner-up Best Oralist of the Victors Moot 2024 is... Ladies and gentlemen, give it up for Miss Anika Sengal, National Law University of Delhi. And now, ladies and gentlemen, to aptly crown the best oralist of the final round. Taking the title of the best oralist of the final round is... Ladies and gentlemen, one more time for Miss Anika Sengal of the National Law University of Delhi. gentlemen, mathematics may dictate that only 3 could get to the top 3. But during 2 days of competitions, we saw some exceptional performances worthy of honorable mentions. And now, ladies and gentlemen, to make a few honorable mentions for the best oralist, I invite Justice Shirani Tilakavardhana on stage. Ladies and gentlemen, please welcome Her Ladyship Justice Shirani Tilakavardhana on stage to give away awards and accolades for honorable mentions for the best oralists. Ladies and gentlemen, we have 3 honorable mentions for the best oralists of the Victors Moot 2024. And in no particular order, the names are ladies and gentlemen, give it up for Mr. Donny Christiana, the National University of Singapore, Mr. Ashanti Alvis, General Sir John Kotalawala Defence University, and Ms. Fatima Rabia Husni of Abbott Law School, Colombo. Colombo. Now, ladies and gentlemen, give it up for Mr. Ashanti Alvis from General Sir John Kotalawala Defence University. To deliver. And now, ladies and gentlemen, to crown the semi-finalists who surpassed the other teams and were able to get into the semi-finals of the Victors Moot 2024. Ladies and gentlemen, the first semi-finalist of the Victors Moot 2024. Please give a round of applause to Abbott Law School, Colombo. Comprising Fatima Rabina Husni, Sindhuja Shivanesh Raja, Hana Mohammad Basik, and Shashiruti Dayaparan. Thank you, Your Ladyship. Ladies and gentlemen, it's now time to recognize the other team that made it to the semi-finals of the Victors Moot 2024. And that, ladies and gentlemen, is the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University, the team comprising Ashwath Dinkaran, Surya SP, Dona Gadil, and Sahitya Niruparan. Ladies and gentlemen, let's hear it for the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. And now, ladies and gentlemen, to crown the victor of the victors at the Victors Moot 2024. After 2 days of intense competition, delivering arguments and blows to each other's arguments, 2 teams surpassed all others. One team, in no particular order, was the National Law University of Delhi, while the other team was the Singapore Management University Yong Pang Hau School of Law. These 2 teams engaged in battle royale at the end of this prestigious competition to claim the title of champions of the Victors Moot 2024. And now, ladies and gentlemen, it is time to crown the champions of the Victors Moot 2024. And taking the title home as the champions of the Victors Moot 2024 is... Ladies and gentlemen, give it up for the Singapore Management University Yong Pang Hau School of Law. The team comprising Auki Zen Shemaine, Marcus Crown, Yusuen, and Con Lee. Ladies and gentlemen, the Singapore University Yong Pang Hau School of Law. Ladies and gentlemen, we should also honor the runners-up of the Victors Moot 2024. Ladies and gentlemen, give it up for the National Law University of Delhi, the team comprising Ishak Jain, Anika Sengal, Abhinav Kumar, and Adarsh Shukla. Ladies and gentlemen, one more thunderous round of applause for the National Law University of Delhi. And with that, ladies and gentlemen, we've concluded honoring the champions, the special award winners, and all the participants here with us today who took part in the HV Pereira QC Memorial Moot Competition 2024. And to formally conclude the day's proceedings, I now invite Chairperson of the Victors Moot 2024, Mr. Tisuru Hettiarachi, on stage to deliver the vote of thanks. Ladies and gentlemen, welcome the Chairperson of the Victors Moot, Tisuru Hettiarachi, on stage.
Good evening to the distinguished invitees, Guest of Honor Dr. K. Kanagiswaran, President's Council, Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, the esteemed arbitrators, valued participants, and the organizers of the Victors Moot 2024. It brings me great pleasure as the chairperson of the Victors Moot 2024 to deliver the vote of thanks at the closing ceremony of the 7th edition of the HV Pereira QC Memorial International Moot Competition. This competition would not have been possible without the invaluable support rendered by the well-wishers and supporters of the Victors Moot that we treasure. And I am honored to have the opportunity to extend my gratitude to these individuals and institutions. First and foremost, I would like to extend my immense gratitude to our guest of honor, Dr. K. Kanagiswaran, President's Council, for gracing us with his presence and making this closing ceremony truly special. I would also like to thank the Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, for your constant guidance in all things to do with the Victors Moot. I thank our esteemed panelists, Dr. Harsha Cabral, President's Council, Mr. Chandaka Jayasundara, President's Council, Mr. Jonathan Chu, and our wonderful moderator, Mr. Shanaga Kure, for providing all in attendance here a wealth of information and a renewed perspective on alternative dispute resolution. I would also like to thank our esteemed panel of arbitrators for the final round of the Victors Moot 2024. Justice Shirani Tilakavardhana, Mr. Chandaka Jayasundara, President's Council, Mr. Muhammad Adamali, President's Council, for guiding us in our endeavors and in expanding the capacities of our treasured participants. I thank the panel of arbitrators for the semi-final rounds and the preliminary rounds for the invaluable support you provided in making this competition a success. I also like to extend my immense gratitude to our valued sponsors, without whom this competition and this closing ceremony would not have been possible. A special thank you to our gold sponsor USAID and Mr. Jeffrey Walker, Chief of Party of the USAID Efficient and Effective Justice Activity, and the ADR Specialist, Mrs. Sarani Gunathilaka. I have no words to express how grateful the organizers are for the immense support provided to us in all our endeavors. I extend my immense gratitude to our sponsors ICLP, Tokyo Cement, My Cola, the Liberal Fellowship, Nitya Partners, and FJ and GD Serum for your invaluable contributions in making the Victor's Moot 2024 a success. I would also like to acknowledge and appreciate the International ADR Center for providing us with the ideal venue in helping us achieve our vision for the Victor's Moot this year. A special thank you to Ms. Damitri Valikala from the ADR Center for your constant support and for always being so pleasant and cheerful to work with. I take this moment to extend my sincerest gratitude to our valued participants. You give this competition so much color, and without you, the true purpose of the Victor's Moot would not be achieved, and for this, we are grateful. I thank the Moot Society alumni who are many in number and constant in support, namely Damitu and Harita, and those who have joined us here today, past presidents Daupadi, Nimanga, Praveen, and all the other past executive committee members. And a special mention to Kavindu Tennakon for the support he has provided us and the continuous guidance he has given us throughout the year. To the executive committee of the Moot Society and the rest of the committee members, I want to express my heartfelt appreciation for your unwavering support. We are truly grateful. Finally, I'd like to thank my organizing committee for their hard work and continued commitment. Thank you, each and every one of you, for your unwavering support and participation in making the Victor's Moot 2024 a resounding success. Thank you.
Thank you, Tisru. I apologize. Ladies and gentlemen, before we wind up this very amazing evening, it has been brought to my attention that due to a few technical issues, we couldn't share the raw emotions and the excitement of the champions and the runners-up of the Victor's Moot 2024. And although we can't replace a moment, let's at least try to relive the moment. And therefore, ladies and gentlemen, let's once again crown the champion of the Victor's Moot 2024. And after hard-fought battles, taking home the title of the champions of the Victor's Moot 2024 is Singapore Management University Yongbang Hao School of Law. The team comprising Avigis and Charmaine, Marcus Wei Swain, and Hon Lee. Ladies and gentlemen, give it up for the Singapore Management University Yongbang Hao School of Law. Ladies and gentlemen, to aptly crown the runners-up of the Victor's Moot 2024. Taking the title home as the runners-up of the Victor's Moot 2024 is Ladies and gentlemen, give it up for the National Law University in Delhi, a team comprising Ishka Jain, Anik Sengal, Abhinav Kumar, and Adar Shukla. Now, ladies and gentlemen, as we close the HV Pereira QC Memorial Moot competition, we reflect on the incredible journey we've shared. This competition has been a testament to the legal excellence and the spirit of justice that the great HV Pereira QC embodied. Our participants have shown immense courage, resilience, and intellect, making HV Pereira QC's legacy proud. As we conclude, let us carry forward the lessons learned and the inspiration garnered. This competition was more than just a test of legal knowledge. It was a celebration of our collective commitment to justice and integrity. Congratulations to all our participants and winners. Thank you for being a part of this great evening. Signing off on behalf of the Moot Society of Sri Lanka Law College, I'm Aditya Edirisinghe. It was an absolute pleasure to host for you this evening. Thank you, ladies and gentlemen. Safe travels home.